You need to accept,
Okay.
please.
Yes.
Yeah. So the meeting is already being recorded.
Okay. So hello everybody. We'll wait 1 minute or two so that we give people time to settle in. Okay, 1 more minute and I will start. Okay, welcome everyone. I'm Sophie Stella-Bourdillon, co-director of the Brussels Privacy Hub, and I will be moderating today's webinar. We have an hour together, and we hope to give space for interaction with you. So write your question down, or just raise your hand if you prefer. We'll be very happy to actually engage in a lively discussion on the topic of data governance. So it's not exactly breaking news, but the European Union is somewhat under increasing pressure, and many are wondering whether the EU is taking or will take steps to maybe take control of its destiny finally. For a few years now, the EU has positioned itself as a pioneer in data governance, experimenting with data regulations of many sorts. It has introduced new regulatory frameworks, such as the Data Governance Act, the DGA for us today, but also the Data Act, the European Health Data Space Regulation, and a few others. And the EU has advanced narratives built around European data spaces, which were announced with great fanfare in prior policy documents. The DGA, in particular, includes bespoke legal regimes for subsets of data intermediaries and refers to data spaces more than 20 times. Barbara will confirm she has done the counting for us. The ambition seems to emerge relatively clearly. The EU wants to unlock the value of data through a federated approach while safeguarding trust, transparency, accountability, and individual rights. Yet, as it happens sometimes when the odds are against you, the path from regulation to real-world impact remains uncertain. And despite its bold vision, the DGA has already faced skepticism, not least from the European Commission itself, which launched a public consultation on the DGA this past summer. The Commission is now working hard on the data union strategy as a core pillar of its AI continental plan to foster a true internal market for data. Whether this strategy can provide the missing operational backbone for the DGA or risk layering new ambitions on top of unresolved challenges, this remains an open question. Can the DGA truly deliver on its promise, or is it structurally doomed to underperform? But what should we really expect from the DGA? What should we also expect from the data union strategy? What institutional, technical, and legal conditions would be required to make the EU vision work in practice? Are data spaces still part of the vision? And what about data intermediaries? By addressing these questions, this webinar seeks to examine what it would really take for for the EU's governance vision to succeed. And to tackle these questions, I have the great pleasure to welcome 4 speakers who will look at these questions from a variety of perspectives. We will kick off the discussion with Barbara, who is a researcher at VUB, LSTS, and managing director of the Hub on the side. Barbara will try to paint an impressionistic picture of the DGA, sharing some preliminary findings from stakeholder interviews. Hello, Barbara. Then I will turn to Manuel, who will unpack what is not in the DGA. That is the concept of data spaces. And therefore add a technical perspective to the regulatory overview that Barbara will give. Thank you, Manuel, for being with us today. With Manuel, we'll get to discover the different waves of data spaces, move from the narrative to concrete implementation and prototypes, hopefully, and talk about what might be missing, at least from a technical perspective, to make this ecosystem successful. Manuel, I should have said that earlier, is Scientific Project Officer at the Joint Research Center of the European Commission. I will then turn to Gianfranco, who is Executive Manager of the Data Space Support Center and Chief Solution Officer of the International Data Space Association. Gianfranco has a unique perspective. His job is to bring, I'm quoting, his job is to bring light into the still complex and new market of data spaces through insightful communication and hands-on go-to-market support. Therefore, it's particularly well placed to shed light on the data space market and tell us what will happen next. We will see if he confirms that we should not worry too much about regulation, that there is space for data spaces, even if we don't see them very clearly, and that technological dependency must be addressed, or is being addressed, or will be addressed. Finally, last but not least, I'll turn to Bernard, who is CEO at DataJoy, a data intermediation service, which is on the register of the European Commission and an SME. I've recently been told that we should not despair just yet, and that's, again, even if we don't see data intermediaries everywhere, this does not mean that they are not growing. There are many more than the 27 or so that we have on the official list, even if some are tiny. But how are they doing? And how are they coping with technological dependency, and what use cases should we be paying attention to? All right, so here we are. Without further ado, let's start the discussion, and let's get a first regulatory overview with Barbara. Barbara, the floor is yours.
Thank you, Sophie. So I will share my screen just for the sake of showing the correct information for you. So I hope you can see it. Is it working? Perfect. Okay, so as Sophie has mentioned before, I'm a PhD researcher at LSTS and the managing director of the Brussels Privacy Hub. I am doing my PhD comparing the GDPR with the Data Act and the DGA, and these research is kind of the spin-off of my PhD thesis. So it's the idea of looking how the Data Governance Act has been applied since it's coming into force. So almost 3 years, more or less. So let's see how it's going. So I want to give you a brief context for those, the speakers know more, a lot about the DGA, but perhaps the the participants that are joining, the attendees that are joining, perhaps they don't know about it. So generally, the Data Governance Act is a regulation that came into force in June 2022, and following 15 months more or less, and for the data intermediation services a little bit longer time. It became applicable since September 2023. The DGA generally aims to enhance the availability of data by fostering trust through different stakeholders, different, let's say, people in the chain of data sharing, facilitating the reuse and sharing of data across public and private sectors. So the DGA can be divided in three general pillars that are mostly divided by different chapters in the DGA as well. So chapter two, which is the public sector protected data reuse, chapter 3, which is data intermediation services, which is mostly the focus of today, and chapter 4, which is data altruism organizations. So my research is trying to cover these three pillars separately. So I'm conducting interviews on that. So in theory, these three pillars provide the legal institutional framework that allow this, enables and structures the creation, operation, and trust of common data spaces. So ideally, the structure, the DGA creates the basis to provide trust among these people to make data available that will eventually get to the data spaces. Yeah, the term data space appears only 24 times in the GA, only mostly in the recitals, and when it comes to the articles, just in European Data Innovation Board, specifically Article 29 and 30. So for us, the question was, how is this connected? How is the DJ should be the basis for these European data spaces if it doesn't focus in them so much so explicitly? So our main question was, what was the EU vision from a regulatory perspective? What were they thinking, basically, is our question. And does it make sense to just impose these obligations on data intermediation services, altruism organizations, etc., and not connect them with the bigger vision, which is the spaces? So the Data Act also mentions the data spaces, includes this interoperability, and then we have these separated regulations, which are for example, the European Health Data Space. So how these complex systems come together. So my research, very briefly, I am doing this qualitative research design, which is interviewing people just to see on the ground what is happening. I divided in three clusters, so member states, policymakers like public administration bodies, intermediation services, and altruism organizations. And the idea is to identify the patterns of their answers and to see what's going on in the field. So my population is mainly from the public source that is coming from the Commission. So member states, policymakers that are on the list of the Commission that is published there, the data intermediation services that are registered there by the member states and are in the Commission website, and the data altruism organization that are also on the website. So as Sophie mentioned in the introduction, it's like a religious situation. They are data intermediation services are everywhere where the eyes to when you want to see them, you will see them everywhere, but we only focus on the ones that are registered on the website of the Commission. So the main key takeaways so far from my interviews regarding the member states policymakers, the positive factor is that, for example, for the reuse of protected public sector body data, is that they already had some structure and know-how regarding the Open Data Directive. So those member states that were focusing on that, they already have the structure. So they are basically adapting the structure to the DGA as well. And the main point also from them is that the innovation board seems to have a very good, it is a good environment for them to exchange experiences, not just in this chapter of the DGA, but also on other chapters, how to apply, how to create a standardization process for the registration of data intermediation services, for example. But negative factors are a thing. So, for example, they lack personnel, funding, and sometimes expertise to comply with the DGA, plus the other regulations, so how it intersects with the GDPR, Data Act, AI, so this is something that they mentioned. They are still not sure how to share the data that is protected, that is held by the public sector body. So it's something like, okay, we are obliged to do that, but we are not sure how to do it. And some of the interviews also showed that the commission particularly has more focus on other chapters of the DGA, particularly the chapter regarding data intermediation services, than the other chapters of the DGA. And this makes them feel like their needs as public sector bodies under this chapter particularly receives less attention than others. So it's something to consider as well. Regarding the data intermediation services, the overwhelming result is that they like the registration process because it gives them the seal of approval that they are trustworthy, that they have a business that will take care of their data, and that they can be trusted by the other people. They like also that some of the definitions of the DGA are kind of vague because it's quite flexible. So if you check the website of the Commission and go through data intermediation services, they are very distinct from one to the other. Like they are very different. They have different business models. This comes from the fact that the DGA is quite flexible in these definitions. So there are a variety of data intermediation services, which is good for the business landscape. Also, member states public services when it comes to the registration process was very responsive, although that sometimes they didn't know more or less how to proceed with it because it was very new. Even so, they responded willingly to register. One of the negative factors was the lack of support from the Commission and member state to create this environment for the development. There's not much knowledge, spread of knowledge to the public, such as something that we see with the GDPR. So there's not this effort to make people know what are these data intermediation services and where they fit in the data governance landscape. So there's lack of information spread to the public and understanding the needs of data intermediation services. So how the Commission or member states can help in the business model. So how can they offer this to make this environment less difficult for them to thrive. And finally, the data altruism organizations, the positive factor is also the seal of approval. So this is something that is overwhelming with all of these stakeholders. And the negative factor is the lack of understanding from the public and also from the Commission that the data tourism organizations do. So some of them in the interviews mentioned that they applied in project fundings, and the reviewer from the Commission said that they didn't see what was a data altruism organization. So from the Commission, there's also this lack of connection between some parts of the Commission and what the Commission itself is doing. So no clear connection between the DGA also and the common European data spaces. So how these data altruism organizations fit, particularly, for example, in the European health data space, how they fit in the system of sharing data. So these are the preliminary results of my interviews. There are more to come, but so far these are the good and bad news from the DJ in practice. Thank you.
Thank you, Barbara. One quick question building on Gianfranco's question, actually. Why is it that some data intermediation services or data intermediaries in general have decided not to register?
Well, I have two answers. One that is what I think, and the other is what the interview gives to me. So what I think is that they don't register because the Commission, for example, the DGA, let's say, forces data tourism organization to register, but data intermediation services don't. So they can continue their lives without registering. The interview says that because they don't want to comply with the rules of the DJ. So they can choose not to register because they have a business model that allows them not to and continue. But I guess those that want to comply with DGA and be good people and want the seal of approval, they go there and register, maybe because they are still developing their business process. Yeah.
John, probably you want to add one tiny thing before we go to Manuel?
What Barbara described is also my experience of it. The way it's been designed, it makes being registered a kind of an optional, nice thing to have that only adds potentially duties on you. So why would I do it? Unless I have a clear business model by which that little logo or brand makes a big difference to me. There's one extra one that I've heard in the grapevine, let's say, that perhaps Barbara did not register, that is, there is a sort of anti-Brussels effect as well. That is, some intermediaries do not want to be seen as European, because then they will see that, oh, there will be too much restrictions and too much limitations of what they do. Particularly if you want to do business with China and the US, you don't want to be associated with the EU, because it's a kind of a symbol of, those are the good guys. I want to be a bit nasty there, right? So and it's an interesting one, right? But it is part of this reasoning. The intermediaries may not want to be seen as too squared sometimes.
Okay, interesting that you mentioned the anti-Brussels effects in this space in particular. Before we actually go to Bernard, who might also have some insights into the question, let's draw the complete picture and also try to have an understanding of what data spaces are in practice. I want to give the floor to Manu so that we can have a short introduction to the topic. Manu, the floor is yours.
Thanks a lot, Sophie, and good afternoon, everyone. I'll share my screen so that we can discuss data spaces, and hopefully you should see it.
Yes, perfect.
Thanks. So in the presentation, I'll focus on data spaces and especially on common European data spaces. My name is Mario Vacco. I work at the Joint Research Center of the European Commission as GRC, we support EU policy with scientific independence throughout the policy cycle. Sorry for my voice. My allergy is kicking in this period of the year. So the GRC, the Joint Research Center, is an independent directorate, and it's policy neutral, and we work we support the policy department. So let me start from the beginning. Let me enlarge a bit the picture, because data spaces are one of the key assets to enable the vision of the single market for data, which was described in the European strategy for data. So we are going back to 2020. The idea is that data can flow in the European Union across sector, and this would be for the benefit of all. So again, to create this single market for data. And of course, all European rules, those about privacy, data protection, competition are fully respected. And among the tools, the means and the instrument which you see on the slides, you see I underlined the part on the possibility to use and reuse data in key sector, and there is a key reference here on common and interoperable data spaces. So let's put other pieces of the puzzle together, because the DGA is one piece of the puzzle from the point of view of regulation to build this European strategy for data. You see here there is mention to four key acts: the DGA, which Barbara just described, the Digital Markets Act, the Open Data Directive, and the Data Act. So in a sense, putting all those four pieces together, we have a legal landscape that provides the what's needed for data spaces to be built, and for more in general data sharing to occur. Now, when we discuss the single data market, one could think that the single data market is the same as data spaces. The objective is to facilitate the creation of the single data market through data spaces, but I mean, data spaces, as I said, is just one part of the strategy. And this comment also applied to data intermediaries. Data intermediaries have a purpose per se, but of course they also have a purpose within data spaces, and I will touch on that later in the slide. So let me try to define, and this is one of the most difficult things. Let me try to define what is a data space. A data space, well, there's so many definitions in legal term, in scientific term, in technical term of data spaces. Probably one of the simplest, yet complete way, in a sense, to describe data spaces is to think of that as a data sharing ecosystem that are sovereign, trustworthy, and interoperable. So those three elements are really key. There are already data sharing ecosystem out in the wild, let me say, in the market. So data spaces are not creating something new from this point of view, because data sharing it's already there. What data spaces put the stress on is on interoperability for starters. So data spaces are trying to identify a common set of, for instance, technical specification. This, because of my background, I'm a software engineer of technical specification for data sharing to occur as seamless as possible. At the same time, you want a sovereignty, and in this context, we read as sovereignty, the possibility to control what happens with my data. If I'm a data provider in a data space, so I'm sharing my data, my industrial data, say I'm a company, I want to control who has access to my data, what they can see. So in a sense, I want to fully understand what they can do with my data. And also trustworthy, because there is a clear set of rules, there is a clear, well-defined governance, which I can trust to make sure that data sharing happens according to those rules. And data spaces can decide their governance. So it's up to each data spaces to create a governance body and to agree on rules and terms for data sharing. Another way of seeing data spaces is, well, considering what I said before, that there are already many data sharing initiatives out there. A data space is a federation of those already existing initiatives. So in a sense, it's bringing them all together and agreeing to common rules and governance. When it comes to common European data spaces, so the one that the European Commission is pushing forward, we have 14 of them, which you can see in this slide. Together with the other pieces of the puzzle. So you have the legislation on the top, so to set the legal certainty for data spaces to thrive and for data sharing to occur. And of course, we have, if we look below in here, we have standards. We have digital identity to access data spaces. We have also software solution like the simple middleware that the European Commission is putting forward as software solution reference software solution for data spaces to be built. And of course, we need high performance computing. We need, I mean, there's a mention here on testing and experimentation facilities. So those large sites in which you can use AI and interact with data using AI in a sort of secure processing environment. So let me dive a bit in, and don't be scared of this picture because I'll guide you through the data space. I'll focus just on the key elements in this. And this picture has been taken from the paper you read below, which try to describe what are data spaces, looking at the way the scientific literature has been looking to data spaces. So I mean, it's a combination of different elements, different actors interacting together. And I mean, this is one way to describe how the technicality of data spaces work. So let me start from here. We have data, we have a source of data. So we have a data producer, someone has data. Again, take the case of a company, of a public body, as was mentioned before, and those data are to be shared. The data holder would like to share the data. So from the point of view of data spaces, this is a data producer. On the other side, we have a consumer. We have a data consumer, so someone who's interested in those data and would like to access those data. Now, how can those two, producer and consumer, be put in contact? In data spaces, we have what is referred to as metadata broker. But apart from the name, think of it as a search engine. A consumer is interested in specific type of data. You can query the search engine of the data space, and once you identify something of your interest, then you can send a request to the data producer to access the data. What will happen is what's here in the middle. A contract negotiation will start, and the two parts will likely come to an agreement for the use of those data, and of course term of use will be shared. An important thing to mention here is that the use of those data could be subject to fees, so the data producer can monetize their data by selling to consumer. Well, the other pieces I would like to highlight in the picture is the possibility to have intermediaries. So in a sense, this is the answer to the question before. Data intermediaries are also foreseen as part of data spaces. They can provide a variety of different services to the other actors, say to data producer or data consumer, to streamline the way a data space works. Just for the sake of the example, let's imagine that I'm a data producer and I want to share my data, but I should make sure that data are in the correct format, are properly, in a sense, prepared for data sharing. Well, an intermediary can help you with that. Or let's look at it from the other side. I'm a consumer, but I do not have the capabilities to run specific data processing, or I don't have a secure processing environment in case data are confidential, are sensitive. Well, I can rely on a data intermediary that has those characteristics to do this on my behalf, so to act as an intermediary between me, the consumer, and the producer. There are, of course, other pieces modules in this picture, which I won't describe for the sake of time. But of course, if you're interested in those, please ask question and we can discuss. I'll close just, sharing a couple of report, a couple of publication from GRC, specifically the team in which I work. The first one is called European Data Spaces, and it provides insight on data sharing and utilization of those data at scale. And this is a very interesting reading to understand a bit more what European data spaces are. And the second one is on technological enablers for privacy preserving data sharing and analysis. The idea behind this report, this study here, is to highlight, identify, and discuss what are the enablers, also in the sense of software components that can be used to make sure that sensitive or confidential data can be reused, while at the same time respecting the sensitivity of the data. And there is a number of different solutions, and those are what are typically referred to as PET, privacy enhancing technologies. And that's it. I'll stop here. Yeah.
Thank you, Manuel, for this overview and this beautiful drawing, and sharing some positive reactions to this beautiful legal landscape that we have in the EU. At least made of different pieces, and it's good to hear from you that you think having different pieces makes sense. Just for clarification, because there is another concept that we see in several regulations, which is secure processing environments. Can you just go back to that distinction, data space, secure processing environment? What are the main differences, very quickly, just to make sure we have the concept.
Yeah, very quickly, a data space is, say, the term to identify a data sharing ecosystem, so in which you have different actors sharing data. Those data are not supposed to be sensitive or confidential. They can be other kind of data. But in case you have confidential data, if we're discussing, for instance, industrial data, or sensitive, if it's the case of personal data, then you would like to share those data to allow the reuse of those data, but without compromising the privacy. It means that there is a third party that can provide a safe space in which those data can be temporarily hosted, where analysis and processing can run, and the consumer only gets the results of the analysis without never seeing the raw data, the sensitive data. And once this is completed, the third party will delete every copy of this sensitive data, so that the data subject and will be sure that those data are not circulated without consent.
Okay. Okay. So one type of control environment, which is essentially one modality of access. Thank you, Gianfranco. You wanted to react? I see you.
Yeah, if Manuel doesn't mind, I wanted to add one element to his conceptualization of data spaces that is correct, but does not come out from the picture. That is, we started talking about data spaces back in 2020 because there was an assumption that perhaps it's not capturing the legislation's text and everything. That is, we are a bit concerned about data, say, platforms. So the data space does not need the participants in this ecosystem to have differences in power. We are not assuming that there is a super powerful agent in the ecosystem that helps administering this system. The participants are expected potentially to be completely peers, whether they are intermediaries or the consumer side or the offer side, they are peers. There is no super user or super host that is orchestrating the whole thing. The picture is consistent with this, but it doesn't pop up, right? And that is where we started talking about data spaces, because we wanted to highlight that we're not talking about any data platform that could still be described by that picture if you think about it, but we want to get away from a place where we need a super powerful host to administer this system.
Okay, thank you. Which is why we see these gatekeepers being mentioned also, for example, in the Data Act, to try to avoid monopoly over data to go even further. Now, going from this beautiful drawing to the practice, Manuel, can you just give us maybe a couple of examples from the sectors? I don't know, maybe like automotive, for example, where we see such data spaces into action actually working?
Yes, there are examples in the market of data spaces. Again, those are not common European data spaces. Those are just a set of actors who decided to share the data among them, and those ecosystems are actually closed. You cannot participate to those unless you have a clear stake in that. One example of that is the Catena X data space, which is about automotive data in Europe. And so we have the biggest manufacturer in the sector sharing data among themselves. So they have agreed how to do that. They have contracts, terms, they have their own governance to do that. but this is and this is a data space. Again, this is a closed data space. I cannot join the Catena X because I'm not in. I do not work in the automotive sector. Instead, if we look at the common European data spaces, those are open to participation to everyone. Of course, there are rules to access to onboard the data space. And for instance, one of the most mature probably in the sense is the health data space that was already mentioned by Barbara. They have specific regulation, and the idea is to facilitate the sharing and the reuse of both primary and secondary data, the so-called primary and secondary data in, in Europe. There are so many examples. I invite those who are interested to have a look at the so-called data space radar, which IDSA, so the International Data Space Association, maintains, and in there you have hundreds of different examples of data sharing initiative that could be called data space, also categorized according to their level of maturity.
Okay, thank you, Manu, for these references. Gianfranco, I'm
Yes.
turning to you now. I initially wanted to start with a question involving regulation, because at the Brussels Privacy Hub, of course, we look at regulations, and we are wondering whether we need some regulatory foundation to further develop, assuming we go in that direction, the data space narrative. How would you respond to that?
I would say that you should actually not rely too much on regulation. So the reason itself, and this perhaps will answer something Barbara was wondering earlier, that is why data spaces are so little described in regulation. That's because they pre-exist regulation. The concept was created about 10 years ago. It's like if regulation had to define every term it uses, like what's a house, what's a road, and everything, right? Sometimes it's necessary, but if you can avoid that, you avoid it. And of course, data spaces as a concept is still very new. It may have, benefited some support from legislation. But why I say we should not need regulation to tell us what to do in this case? Because I don't think regulation wants to tell us what to do. Data spaces can be seen as a model for governance. And what Europe in writing regulation wants to tell us is what is legal and what is not how you do it. So a data space as a model of governance by which an ecosystem can share data, as Mario explained, is just one way by which you can achieve compliance. You may have an old-fashioned data portal or data platform run by an evil digital American company, and just joking here, but you got the point, and you may still have a data space there if you play the game that way, if you ensure that the participants have the same kind of rights, if you don't create monopolies, if you don't have disparity of power in the participants and so on. So from that point of view, the legislation will not be able to go down to the detail. It's more something that we specify at a higher level or lower, depending on how you see it. That is what usually we call the rule book of a data space. That is, okay, we know we are moving within a certain regulation. Perhaps all of the participants of these ecosystems are in Europe. So we all know, we all are aware, we are subject to European legislation. And then we join one specific data space. And in joining, usually we sign up to some rules, sometimes described in something we call the rulebook. And that rulebook will define in more specific terms what the law cannot tell us. So perhaps that data space decides to be very decentralized, which means that, for example, we may have lots of those metadata brokers that Mario described. There could be even competition for the same kind of services, multiple search engines, multiple clearinghouses, for example. Or it may be a bit more of a conventional, simpler kind of data spaces that actually looks more like a platform in which there is a super powerful orchestrator that perhaps decide that there is only one search engine, and I run it, by the way. And if I don't like you, I will not let you enter my data space. But some of us would not call that a data space because of that disparity of power, that kind of control. Even the term is so abused sometimes, and that our audience needs to be aware of that. So it's not a bad thing. Be relaxed about it, but be aware that a data space may be, from a legislative point of view, maybe a very, very wide, let's say, large, loose concept. If you ask someone like my employer, let's say the association for the International Data Space Association that has been defining this stuff since 9 years ago, they will give you a much more restricted kind of definition that makes, for example, decentralization a necessary requirement. We do not want those super powerful orchestrators. While for European legislation, they will say, okay, fine. You see, same term, but slightly different flavors of it. I could talk for a very long time. You know me, Sophie, so you need to stop me.
No, it's good to have these precisions, and so it's a loose term, but is this driving practice on the ground?
No. I would say that, well, like in most things, I would say the practice is something you learn from practice, from the ground. I would say legislation particularly, and again, I'm not a scholar here, so you may slap me anytime you like, but I believe legislation here is more like giving me a feel of where Europe would like me to go without putting boundaries that are too strict, and not necessarily not to help me, but actually not even to restrict me. So there is a kind of general feel that we want a fair single data European market that is sovereign and trustworthy. The word that we always use, also Mario used that before. But I will not tell you exactly how to do it. That's not the European Union's job. They don't want to do it. In the same way, probably your national government will not want to tell you down to that point, which means that the only good patterns by which you achieve that is something you can see in practice from other data spaces built before you. And again, because the model is so new, unfortunately, we can't find thousands of them. You can't buy the Harvard Business Review book of data spaces yet. So you will have to browse through the data space radar, as Mario said, possibly actually do some footwork, interview the data spaces closer to you in terms of intention and use cases, and pick and choose what the best bits you like to build your own rulebook and so on. Knowing that the legislation will always be at the back, say setting the wider boundaries, but ultimately you will give yourself the rules. I tend to compare data space sometimes to tennis clubs. The tennis is the same. But you choose to pick one tennis club in particular because it's close to your place, because perhaps you're posh and you want to dress in white, so you go to Wimbledon. But tennis is the same. So some of these topics are a bit artificial, right? The common European data spaces, the fact that they are funded by the EU or not, the fact that they are open or not, they are all detailed. Ultimately, you will choose the tennis club whose rules you can accept, that is in line with your kind of principles and values and business drivers, and then you just play the game. That is still tennis, like in every other tennis club.
Okay. Building on that, I see also a question in the chat that is wondering actually why. So you speak about tennis clubs, but there is a variety of tennis clubs. They might not have all the same rules. Why is it that there's not been any serious effort to consolidate or align these frameworks for easier implementation and cross-border compliance?
This perhaps is more for the legislators among us. I don't know, Mario, but in the end, I believe there is the intention to address that topic. It's what we usually call exactly cross-border data transfers. Usually, it's a kind of a perpendicular topic to data spaces. So if we assume we are only moving within Europe, we know that we have the regulatory environment that Barbara described well. It's a bit more comfortable because we know it a bit better. And the problem starts when we bring to the tennis club a foreign player for whom those rules do not apply. And that breaks the whole balance. So when we move within Europe, let's say we are moving within our environment that are better known. It's simpler, it simplifies, but it sets parameters within which we move. But this does not mean that the game of tennis changes. It may break simply because that player is not subject to the same regulation we are. It's not up to the data space necessarily to manage that. It's not up to the tennis club to decide the rules of tennis. But it's up to the tennis federations, the governments in this case, to find those cross-border agreements for data transfers. And that's what Europe is working on. I don't know, Mario, if you want to add something to that point.
Yes, what I can mention on this is that the same concept, so the idea of data space, as Gianfranco said, is something not really new. You can find, trace of that in the literature since probably 20 years ago. Probably the name was different. And for instance, on this, if you take the case of the US, they have been studying something called data mesh. In a sense that the concept of data mesh is very similar to the concept of data space. And so this is not something that, as Gianfranco said, the Commission invented. It's something that was already out there. And I know experiences in the US in this sense, but also in Japan, for instance, and which according to our view can be described as data spaces, and there is great interest in understanding better how those different initiatives can work together. In the end, if you think of it, if there's the rule book Gianfranco described before, the set of rules that is used to run data space, and of course this rule book complies with European law, well, partners, organization, participants, also from abroad Europe can decide to join that game and respect those rules. There's no limitation in that respect. And of course, this can also happen inter data spaces, so between different initiatives. Yeah, exactly. There is also China, Australia, Brazil. There's a number of those.
To add to that, Mario, in the end, the way today we're using the common European data space is just a short way to say that data space is designed to be compliant with European Union terms, but this does not mean that you must be European to share data in it.
Okay. And to the legal scholar, it might be that data spaces are going to give us the context that we need to fine-tune our cross-border data transfer rules, but more needs to happen also in that space where I understand the ins and outs. Gianfranco, one last question and quick question. So you look at the data space market. Is this taking off? Are you optimistic for the future? If not, or if you see obstacles, what are they and how do we move forward?
Yeah, perhaps market is not the best word in this case, because you may say the data space itself is a market. So it's a market for markets. Perhaps yes. We usually analyze let's say the level of maturity, or say the challenges that data spaces are experiencing against 3 dimensions: technical, business, organizational, and legal. From a technical perspective, I would say it's not really a problem. I don't want to make it sound bigger than it is. We have the technology to do it. It may not be as mature, as automated as we would like it to be. We don't have robots going around sharing data every day like we are aiming at in the future, but the technology is less of a problem. And some of the technologies are being standardized with the capitalized international standardization at the ISO. For example, the data space protocol will be a standard by 2026, which is quite an interesting advancement to give security and safety to the ones investing in this technology. From a business and organizational perspective, the challenges are related mostly to find business models that work well for you. But again, this is not news if you think about it. Whether you use a data space or a traditional data sharing platform, you still need to decide to play the riddle of how to price a data set. That has always been a challenge, whatever the model you use to share it. And some organizations that today decide to go into data space or data sharing still do not know well how to put a price on the data they can offer to the others. And legally, you teach me about this. We know all the challenge that comes from Data Governance Act and its brothers and sisters being, as we said, a bit loose, which means that usually you will often find legal offices in organizations saying, you know what, I don't really know what I can do here. I don't know if I'm doing the right thing. There are no best practices I can rely. There are not, again, that not the Harvard Business Review book, but the legal whatever reference, which means that many of the legal colleagues who need to advise us when we want to join a data space or start one will not know exactly what to use as a reference. Besides, the Commission told us there will not be much more data legislation already 1 year ago, but they started saying they actually now more tending to release, or after the Draghi report, we got a bit burnt by the idea of limiting the opportunities for entrepreneurship because of legislation. This does not mean we want to become a land without the rules, but at the same time, the problem shifts a little to educating entrepreneurs that want to start a data space in the same way they would start any kind of business, to feel comfortable that they understand the legislation that applies to them, they know what kind of business models they can use, and the technology can be solved by relying on suppliers, consultants, advisors, services that are ready for you to help.
Okay. So you continue to be optimistic.
I've been working in this stuff for 12 years. I need to be optimistic. Otherwise, I would be very, very in trouble.
Okay, no, but that's great to hear. We shouldn't think too quickly that these questions are not important. Moving to the data intermediary, which a data intermediary may be a participant to a data space or may not. We are lucky to have one with us today, Bernard. If you hear me, maybe you have an answer to the question I was posed earlier, which is why is it that data intermediation service would want to be registered and appear in the register of the European Commission?
I can echo what was said before. There's little incentive. Can you hear me?
Yes.
Yeah. I would say there's little incentive. Basically, when you look at the Data Governance Act, there's a nuance between two levels. There's the standard data intermediary, around 20 of them, which are registered in the official register. And then there's officially recognized in the EU label, which has much more stricter requirements. And I think a mistake that a lot of people did is they mixed the two together, and they thought that to be, can you hear me? Yeah?
Yes.
Yeah, perfect. I think the mistake that a lot of people did is they didn't see the nuance between the two, and so they didn't see the added value of doing those requirements. And also, even if you go to the official register, you don't see the data intermediaries that have obtained the labels. So even if you go to the extra step of fulfilling those requirements, there's no really official way to prove to a company, hey, I got this label. Then another reason I see why there's so few data intermediaries is you can represent either companies or citizens. And in the case where you represent citizens, it's hard. So it's with a QES signature, you can easily give the proof of name and date of birth, but not of the phone and the email. And you need this as a proof to convince data holders to share companies, data holders, data controllers to share companies. And this is an issue that's not addressed in the EU digital wallet, for example. Another thing that I think see as a reason is that it's a branding issue for entrepreneurs in the EU, where they don't see EU data space as sexy. I think it's a branding communication issue. It's not that the model doesn't work, it's more a branding thing. And then there's something where the DGA as itself doesn't add a new right. It's not like the Data Act or GDPR that gives new right. It's a quite complex legislation between Data Act and GDPR, and so it's just reinforcing. It's needed, but it's just reinforcing existing right. And I think that's it's less sexy for entrepreneurs. Entrepreneurs tend to jump to AI Act and see, okay, is there opportunity in there? Yes or no, and so they don't tend to look at the Data Governance Act.
So building on that, and maybe just a short answer is needed for that. Has the DGA made a difference for you? You're of course at the beginning of your journey, but so far, yes or no?
I will be able to give a better answer in 6 weeks. But for now, I would say when I contact companies, most companies don't answer. So concretely, not so much.
Okay. What would be the one thing that would need to happen to change, to accelerate the trend then?
Maybe I would say two things. First, the branding issue around EU data, and then also we have a problem with proof that it's hard for data government or data intermediary to represent with a solid technical proof towards data holders. And so there's a technical. It's possible to find workarounds, but it's quite complicated from a user experience point of view currently.
Okay. Okay, and just to better understand where you are at, of course, so you've got lots of very interesting ideas about use cases and so on. Before we go into the use case piece, of course, you are a small player, and there's lots of worry about the need to have a sovereign data architecture infrastructure here to facilitate the development of players like you. Are you seeing any signs of reduced technological dependence on foreign infrastructure in your space? Is more needed to go in that direction, do you think?
For the technological stack needed for data intermediaries, it's quite standard. So from that point of view, no. But overall, in startups around me, there's in the last year or two, there was a huge increase on dependence towards US and China, I would say.
Okay, so do you want to express any wish in that direction, or it's too early to say anything at this stage?
I would say it's hard. I don't have a solution because on one side, the EU has a branding problem with being too burdensome for the companies. But on the other side, a reason why the Data Governance Act doesn't work is because there's not enough fines given when they're not giving the data when they should. So it's a hard balance. There's no easy answer.
All right, and now moving to use cases, I wanted you to, maybe to speak about a few very interesting use cases for which data intermediaries could make a difference. Do you want to share
Sure.
things there?
So most data intermediaries choose a vertical, like, for example, agriculture or something, and they build a lot of services around it. We try to be more a neutral building block, so we help other companies to embed in their user journey a step where they can collect the data from citizens or the company and send it to a data recipient. So we try to be industry neutral. Of course, we have some. So we have two use cases especially in mind. One is giving the data to consumer defense organizations. Of course, with the agreement from the data subjects, because this way, when the data holder doesn't give the data, the consumer defense organization are strong enough to make a lawsuit. And the other is AI assistants, and these AI assistants can run locally, and basically they would get data from Amazon, Google, the store, and so forth, even when those data holders don't want to share the data.
Okay, very interesting, and thank you for sharing your views. And I hear you clearly. If DJ has to have an impact, then we need to enforce GDPR correctly. That's very clear, and that's very useful to have you say something like this. Hopefully some people are hearing that. Gianfranco, do you want to react to what Bernard has been saying, or Manuel or Barbara?
There's one point that also was coming from the questions in chat, that is, at some point, everything, all the great things we are describing break with enforcement. And I'm sorry to raise this pain point for everybody, but we may say, okay, fine, if we don't follow the rules, someone will be punished, right? Really? Unfortunately, we don't have a great record of that. I mean, and Barbara and Sophie, you may actually tell us about it. Just think about GDPR, that has the longer history of the law of data legislation we're talking about. How many fines were recognized? How many were actually paid? I believe none. If you look or watch on YouTube any speech by Max Schrems, this is the Austrian famous lawyer who was the first to take Facebook to court. He will tell you that all of the fines that were ever issued against violation of privacy, for example, were never paid by none of the big giants. There is extreme fragmentation of our data authorities in the countries. The rules by which they work are very different. Every country behaves differently. So you may have extremely high cost if you want your rights to be protected or violation to be recognized, which makes sometimes even completely unpractical to even try to get your problem recognized. So in this context today, and also thinking to Paul Bernard, how can he make the point of the value he brings to this picture while everybody can pretend not being an intermediary, not to register, take advantage of this kind of being optional. And anyway, even if they do whatever they like, we are not going to be punished. That is where the whole system breaks, I would say, today. And if you ask me what would be my top urgency here, is to help the member states in strengthening and creating consistency in enforcement. Because as long as everything works fine, everybody's happy, great opportunities, data sharing, business, blah, blah, blah. And then someone breaks the rules and everything crashes.
Thank you, Gianfranco. Any other reaction from my panelists?
Yes, what I can say on this is that, I mean, thinking of what Gianfranco just said, especially from the point of view of data spaces and the technology in there, some of the trust, some of the rules to be respected are somehow programmatically coded in the components. So this is another piece, I mean, of the trust, of the certainty you may need in this context. I'm not saying this is enough, because of course there is something that we will always go to, say, for instance, to court. But if you can identify a viable and interoperable mechanism through which you run, for instance, in this case, data exchanges, and you're able to identify a software solution that works for all the participants to that initiative, well, you also have the opportunity to, in a sense, codify those part of the rules, and in a sense put a bit of trust in there. And when this code is open source, so that everyone can see the code and double check the way it works in there, this is a part of the trust. And when it comes to data spaces, the Commission is doing that. I mentioned Simple before, which is the software solution, the middleware for data spaces, and in their components are being developed, I mean, compliant to the legislation. So in a sense, this is another piece you may want to add to the puzzle to enforce the whole picture. Of course, this is not mandatory to use. This is a reference implementation, but if adopted, it's something that could, reinforce the whole picture.
Yeah, thanks, Mario. You counterbalance me there, because if we reduce the degree to which we depend on arbitrary human processes, of course we narrow the space for abuse, and that is where the technology efforts are today. So, can we automate compliance? Can we support our legal colleagues in doing all the checks they need to do without knowing to-do list by heart or reading the book every time? Right? Can we limit the space of error, as simple as that, so that if someone is really abusing of our rights, it's because they really were bad intentioned. Even just limiting the space of human error would be amazing progress from this point of view. And it's not the data space that changes this picture. I can abuse of your data on paper if I want to. That's not the point. The computers are not the problem.
All right.
Yes, and for final comment on this, I'll be very quick. It's not that this one is the solution. Of course, you will need human experts. You'll need legals in this whole picture. But if you can reduce the space of maneuver for those who want to do something bad, well, that's something you should at least consider as an option.
Yes, I mean, of course, the space of automated compliance needs to be nuanced, and I don't think anyone is saying that we need to substitute the lawyers with the code. It won't work. Thank you. One last question, because this is something I've heard often. So we've been mentioning the rules in the DGA and the regime that is governing data intermediaries, and in particular data intermediation services. Are they too restrictive? Do we need to change them? Who wants to take this question? Should we allow data intermediaries to do more with the data?
Some of my colleagues would say that we rather need coherence rather than reduction. So my colleagues in the SSC, in Data Space Support Center, Kevin works with us, and they often simply claim that we should worry about consistency between the different regulations rather than reducing regulation. Reduction, perhaps it's an easy way to say it, but what we really need is to check that they are consistent, that the borders match when we put them together.
Okay, thank you, Gianfranco. Bernard, do you want to say anything?
I can echo that as well. Consistency between the legislation would be more than welcome.
Thank you.
And also, yeah, and so yeah, also I think a lot of the issue with the data governance is just people did not realize there were two levels of requirements. So that's more. We can fit that in the bucket of communication.
Okay, so better communication will already be something. Manlio, do you want to add anything?
No, not really on this.
Okay, and Baba?
I have two answers. So on my interviews, the majority of the interviewees said no. So there's no need to open up and flexibilize because they think that it's okay. However, I believe that those that are not registered have another answer to that. So I participated in a workshop led by the Commission, and the majority of the people that were there talking about data intermediation services, they were like, yes, open up, we want to sell data, we want to do whatever. So I guess there are two different opinions. The ones that want to comply are already registered, and those that do not want, they will not register. So they don't care about it.
Okay, but I mean, it should be also fair to say that there is space to improve your services with the data under the DGA, and also to leverage user data, which is not necessarily the same thing as the data that is being passed through the data intermediary to achieve the goal that has been set beforehand. So it's not just black and white, of course, as always. Thank you so much, my panelists, for joining this webinar today. That was a very good combination of perspectives on the topic. I think we've got some important messages from the discussion. Thank you, the audience, for all the very interesting questions. I think we can close now. I just want to also mention that in about a month, we will have a second webinar, which will be dedicated to privacy laws, so hard law, but looking at different jurisdictions, the EU, but also what's happening in the US and in the UK. Thank you, everybody, and see you soon. Bye-bye.
Thank you, everyone.
Thank you.
Thanks. Bye, everyone.